Good morning and welcome to the Court Improvement Project webinar regarding the 2016 legislative session highlighting bills that may be of interest to both child welfare and juvenile justice. We're excited to have over 100 individuals and perhaps more on the webinar from across the state, representing a variety of entities. My name is Katie McLeese-Stevenson and I serve as the Director of the Nebraska Court Improvement Project. The Court Improvement Project is a long-standing program of the Nebraska Supreme Court, and we operate under the guidance of the Supreme Court Commission on Children in the Courts. The goal of the Court Improvement Project is to improve court processing of child welfare and juvenile justice cases. The Court Improvement Project team carries out this goal in a variety of ways, including the education of court stakeholders and supporting the 25 Through the Eyes of the Child teams across Nebraska. In 2016, we'll be focusing on offering quarterly training opportunities. This year, we are planning to offer trainings throughout the year, including various means, both webinar and face-to-face formats, and holding trainings in a variety of locations throughout Nebraska. Of special note this year, September 7th through the 9th, we'll be holding the 4th Children's Summit in Kearney, Nebraska. Information regarding the conference and Court Improvement Project may be found on our website at cip.nebraska.gov. We're pleased today to provide this webinar in partnership with Nebraska Appleseed and Voices for Children. Both are important advocacy groups in our state that are committed to improving systems and practices that affect children and families. With us today are Sarah Helvey, the Child Welfare Program Director at Nebraska Appleseed, who will be sharing information regarding child welfare bills, followed by Juliet Summers, the Policy Coordinator for Child Welfare and Juvenile Justice at Voices for Children in Nebraska, who will be sharing information on juvenile justice bills. Before Sarah and Juliet begin, Sarah Frankel from the Nebraska Court Improvement Project will provide you with information about the logistics of the webinar. If you know of others who may be interested in the content of today's webinar, it will also be made available on our website following the webinar.
So before we get started, just a couple of logistical things. In the very bottom right-hand corner of your screen, you'll see a chat box. Feel free to enter any questions that you have in the chat box. We will take questions at the end of the webinar, but you can go ahead and type them in as they come to you. If you have a specific question for a host, if you hover over your name under the participants list, you can actually raise your hand and we'll click on you and it's more of a one-on-one conversation. And the other thing is we ask that all participants mute their phones. So if you click *6 if you're on a landline or on a cell phone, or you can mute the actual phone because we are recording this webinar. So at this time, I'll go ahead and turn it over to Juliet Summers.
Hi everyone, I'm Juliet. I'm with Voices for Children in Nebraska, as Katie said, and we just want to start by saying a big thank you to Court Improvement Project for all the work that they do, but for allowing opportunities like this to keep people informed about what's going on the legislative end of things. As she said, feel free as we go to write questions in the chat box. If we are able to answer them and we have time to answer them, we'll get to as many as we can at the end. We just want to make sure if there are, say, lots of questions about the juvenile justice bills that I'm going to start with, that the presentation doesn't get overwhelmed. We never get to the child welfare important things that are going on that Sarah's going to present about. I'm going to start actually briefly, Voices for Children in Nebraska. If you don't know of our organization, we are an independent nonprofit. We take no state or federal money so that we can be an outside voice advocating for kids. Our mission principles are that we start from the research and the data. We look at what's actually going on and what the science says about what works. And then from there, we can support policies if they're good. If there are harmful policies or systems issues that are creating negative outcomes for kids, we fight them. And then if there are missing policies that would be further supportive for children, we can create missing policies. And our final mission principle is that community engagement is how we promote systems change, a strong belief that we all have to come together from our different places and different works in order to actually make real change in systems, which is what changes the future for our kids. So I'm going to start with a sort of 101 on legislative session, and I'll blast through it because I don't want to take up too much time, but I think it's important to have kind of a picture of what legislative session looks like and how it works, particularly in a short year. So each legislature convenes over a 2-year period. That's called the biennium, and it's even odd years. So the first year of the biennium was last year. That's a long session with 90 legislative days that stretch from January through June. More gets accomplished in the legislative long session than in a short session, and short session is what we're in this year, which is just 60 days stretched from the first week of January through about April 20th. So we're in the second session. Senators in both sessions can bring as many bills as they choose, as long as all new bills are dropped by the 10th day of that session. And this results in a lot of bills. We have well over 1,000 bills total at this point for the biennium. Each bill that's dropped will receive a public hearing in a designated committee. Most of the bills that we're going to talk to you about today are either in the Judiciary Committee or the Department of Health and Human Services Committee. So we have lots and lots of bills, of course, due to the time constraints of the number of days of session and how much time each bill is entitled to on the legislative floor. Really, realistically, any new bills that were brought this session, they aren't, even if they get through a committee hearing, they're not likely to be heard on the floor by the legislature, much less passed into law, unless they get a priority. Each senator is permitted one priority. The speaker is permitted 25. Sarah will correct me if I'm wrong about that. And each committee gets to prioritize a couple bills as well. So the third kind of bill you should know about in a legislative short session is carryover bills. So there are some bills hanging out there that made it out of committee last year during the long session, but because of priorities and timing, they weren't heard on the floor during last year's long session. And so time permitting, they may be heard during this year's short session. So if you look up at the top right-hand corner of your screen, there's a couple documents that are able to download. So the first is the actual PowerPoint we're working through here. And then the second is a chart of many, many more juvenile justice and child welfare related bills that Sarah and I compiled for you. Just the names and the bill numbers, essentially. And some of those at the very top of that chart are carryover bills from last year. So they may not have had a priority last year. They didn't have a priority last year. They may not get a priority this year, but just because they're hanging out on the floor, they may get heard, and some very early. I think LB 25 is actually on the agenda for today. So that's legislative short session in a nutshell. I'm going to turn to some juvenile justice bills of interest this year and work through those in a reasonable time frame, and then turn it over to Sarah for a similar talk on child welfare. The first bill that I'd like to draw your attention to for juvenile justice is Senator Christ's LB 675. This is a bill that came out of some JDAI work, Juvenile Detention Alternatives Initiative. And essentially what it does is it realigns Nebraska's juvenile code as it relates to rationales for detention to national best practices, specifically eliminating risk of harm to self and risk of harm to property of others as permissional rationales for secure confinement of kids. It also lists certain impermissible uses of detention, which are probably covered by eliminating those two current rationales in the code, but it's a little bit more explicit. So some of those explicitly impermissible uses of detention, for example, are to allow a parent or guardian to avoid their legal responsibility to a child, or due to lack of appropriate alternative placement. There we go. The next bill that I want to flag for you is LB 709, and in some ways it's a sister bill with LB 675. It's a little bit more technical. It essentially implements the term alternative to detention in the juvenile code term section 43 to 45. It's not currently defined in the juvenile code, even though it is used in a few places, and specifically in the portion of the statute regarding the community-based aid fund. So the term that this bill proposes for the juvenile code is the term that's currently being used by the Crime Commission's evaluators, by the JDAI subcommittee, It's been worked on by a couple other committees that are working on things around juvenile justice in the state. It essentially says it's a program or service intended to keep the child, maintain the child safely in the community, thus eliminating the need for secure confinement. And it doesn't include facilities that use physical construction or hardware, like ideas, handcuffs or locked doors to keep kids safely in the community. It also, more substantively, it requires a hearing when a juvenile is placed on an alternative to detention that infringes on their liberty interest. So what we've heard is current practice around the state is just different in different jurisdictions. In some jurisdictions, if a probation intake officer screens the child to an alternative to detention, like an electronic monitor, in some jurisdictions, the young person gets a hearing about that electronic monitor the next day or within 48 hours. In other jurisdictions, they may not. They may not have a hearing, a probable cause hearing about that electronic monitor and whether that's necessary to maintain them safely in the community for weeks or even months. So this bill would also include a statutory right to have that hearing. And I should say with that, it does also permit, though, that the child could waive that hearing through counsel if they didn't want to come into court and fight the use of the alternative. And then LB 845 is one you may have read about. There's been some news about this one. This is Senator Pansing-Brooks' bill on room confinement. So the ACLU of Nebraska produced a report in December, or maybe early January, regarding the use of solitary confinement or segregation or room confinement in different juvenile facilities throughout the state. And not just juvenile facilities, but also adult correctional facilities where minors are housed, young people under the age of 18. And what this bill would do, this bill is just a reporting bill. So this first step is to say, one of the takeaways from the report and the responses to the report was, different facilities are just defining it differently, tracking it differently, reporting it differently. Some may not use it at all. Some may be confining kids to rooms, but only for shorter periods of time, or, comparing apples to oranges, essentially, is what we want to avoid. So the bill provides a definition of room confinement as it would relate to minors, and it would apply to all facilities in the state, residential facilities that are housing minors. And that definition is would be that it's involuntary restriction of a juvenile to a cell, room, or other area alone, except during regular sleeping hours. So that's what the definition is that involuntary restriction. All the bill does in terms of requirements then is that any residential facility housing minors has to sort of track and report use of extended room confinement. So when it's not trying to cut out the immediate, everyone go to your room and take a break and a breather for safety, calm down for a few minutes. It says that, when a minor has been confined to their room alone for 2 hours, a supervisor needs to approve it, and it needs to be tracked, and then we need to be keeping tabs on how long kids are staying beyond that and reporting that information to the legislature. A couple more. LB 860, and I should say all the ones on that previous page, they actually already came up for hearing before the Judiciary Committee last week, and so the Judiciary Committee is considering them right now. So this bill, LB 866 from Senator Bowles, the Transition to Adult Living Success Program, this one has not had its hearing yet. It's going to be before the Health and Human Services Committee on Wednesday. And I'm actually coordinating testimony, so if you are interested in this bill, if this is a bill you would support, we would love to walk into that hearing with a huge stack of letters of support from people across the state. And my information will be at the end of the PowerPoint, so if you want to write a letter of support for it or weigh in, you've got my contact info and you can send me that. What this bill would do is many stakeholders, as we spoke to people across the state over the past year, identified that we have a great program in Bridge to Independence for young people aging out of the foster care system without sort of supportive family wrapped around them. But we don't have anything for young people aging out of the juvenile justice system who might be in a really similar situation. I know from my own personal experience as a juvenile public defender, I had more than one client. I can think of probably 2 hands worth of clients who they came to the attention of the courts because of a charge, a delinquency or a status charge, but they could just as well have come to the attention of the courts through an abuse or neglect charge. And it was sort of the way they were identified by the system. And then that was the way that their case went, and that was the way that services were accessed. And so even though they were aging out, perhaps doing really well at Boys Town or some kind of out-of-home placement, they weren't able to transition home because a parent wasn't involved or there was some safety issue going on, but a 3A wasn't filed. So, and we heard this from the stakeholders across the state, that there's a real need. There are young people who are going from placement on a juvenile justice docket, even detention, straight to a homeless shelter on their 19th birthday, and wanting to put some protection in place to help them navigate their way to adulthood, both from sort of moral high ground reasons and protecting kids and young people, but also from really pragmatic concerns about setting our young people up to fail and increasing versus reducing recidivism. So what this bill would do is it would direct DHHS to initiate a service contracting program. The hope is that DHHS will contract with programs like PALS or Jacob's Place and service providers who are already offering case management and independent living skills for young people, but they might not be currently doing it for juvenile justice youth, just former foster youth. So for young people who are aging out of the juvenile justice system in out-of-home placement, and they've been in that out-of-home placement for 3 months of the preceding 6 months, it would appropriate money for them to get that intensive case management and working on a transition to adulthood plan. They'd be eligible through the age of 21, and for each year they could draw on a critical needs fund up to $1,000 per year for urgent things like shelter, food, getting necessary legal documents like, paying the fee for your driver's license, etc. 893 was another one that was heard last week, and it would sort of realign our code so that for when very, very young children come to the attention of the justice system by engaging in what would be considered a criminal act, a delinquent or a status charge, that they would be treated through a no-fault filing under 43.247.3a rather than a delinquency filing or a status filing. The idea behind this is really, I think if there are people on the call who've represented very young kids or been involved in delinquency or status cases that involve really young kids, I think there's an understanding of just the challenge that presents in terms of ensuring very young children understand the proceedings that are being brought against them, whether they're even capable of signing a probation contract or following through with those orders, and also the reality that for those little 9-year-olds, it is going to be mom or dad doing the work, getting the services arranged and following through and making sure transportation is there. So the sense was changing the filing for these very, very young children from delinquency or status to a no-fault 43.247.3a would both protect against children facing charges they're not capable of understanding, and also, put parents on fair notice that they're going to be the ones responsible for the bulk of understanding the proceedings that are happening and understanding any resulting court orders and making sure they're followed through with. And I think I just have a couple more for you guys. LB 894 is a right to counsel bill that Senator Pansing Brooks also brought. It has a few different pieces related to right to counsel. She got fired up about this issue based on a national conference that she attended, and also upon receiving some information from the state court administrator that only about 66% of young people statewide are represented by counsel in the juvenile court. And she wants to flip that number. She wants 100% of young people who are facing charges to be represented, to have lawyers. And that's really what our national best practice shows, that lawyers are good for kids from start to finish. They help with understanding. I'm probably preaching to the choir on this, but they help with understanding. They help with smoothing proceedings through. They help kids navigate what can be a really tricky and complicated process, and not just to have a trial in every case, but sometimes it's the lawyer saying, the right thing to do is to work out this plea agreement, or, these recommendations from probation are actually appropriate, and here's why you should follow through with them. Here's what your court order means. And here's what it's going to require you to do to protect against a later motion to revoke probation, et cetera. So this bill would require appointment of counsel at the time of petition filing on delinquency and status charges. It would set restrictions on juvenile waiver of the right to counsel, and specifically would say those waivers have to be on the record and they have to be made in writing with the juvenile's signature if you want to waive your right to counsel. There are certain moments in a court case where counsel couldn't be waived, such as at detention or when there's out-of-home placement or YRTC placement on the table. When the child is under a certain age, just saying, you're too young to waive counsel. And also, for any waiver of counsel, there has to be a consultation with counsel prior to that waiver. So a lawyer can sit a child down and say, here's what a lawyer has to offer you. Are you sure you want to waive this? And finally, LB 954 is the one that may, in some ways, have been the one with the most public media coverage. This is Senator Crist's bill regarding Inspector General oversight of the juvenile justice system. So I'm sure probably most people on this call were aware of a sort of blow-up between the legislature and the courts that happened in the fall over the Inspector General's office not getting access to court files and probation files and records in order to investigate cases of death, serious injury, or complaints being made about kiddos in the juvenile justice system. I think there was a long period of compromise and people walking back from the brink to come together. And the hearing on this was also last week. And both the Inspector General and the State Court Administrator, as well as the Foster Care Review Office, testified in support of the compromise that's been reached. And essentially what it would do is assuming that it works out the way it has been promised by the parties at the table, boilerplate language would be included in all judicial orders that would say, in the case of death, serious injury, or complaint, it is permitted that the Office of the Inspector General be able to access reports and probation files so that boilerplate language is already in court order. And then if something, God forbid, like that were to occur, the Inspector General would go to probation and say, hey, I received a complaint, or hey, there's been a death or serious injury. I need access to those reports. And the boilerplate order already being in place would then mean probation within 5 days would have to turn over that information. Those are the juvenile justice bills that I wanted to flag for you today. As I said at the outset, we do have quite a few more in that chart. Sarah and I have done our best to prepare, so if you do have questions about any of the ones in the chart as well, we'll take our best stab at it. But now I'll turn it over to Sarah.
Great, thanks, Juliet. So thanks to Juliet and thanks to the Court Improvement Project. It's always a lot of fun to partner with both of them. Hopefully most of you are familiar with Nebraska Appleseed, but a little bit of background about us. We are a nonprofit, nonpartisan, public interest legal advocacy organization. And we do our work in the areas of child welfare, healthcare access, immigration, and then poverty, public benefits advocacy. And we like to say that we use all of the tools in the advocacy toolkit. So we do a lot of work at the legislature doing policy advocacy and in the community doing grassroots organizing. But we also have attorneys on staff and we do legal advocacy as well, including impact litigation,
And then we also have what we call the Foster Care Reform Legal Resource Center, where we provide technical assistance and other resources like amicus assistance to help attorneys create positive precedents in juvenile court cases. And it also helps us to identify the needs on the ground for systemic policy change. So feel free to email me. My contact information is on the last slide as well. If you are a practicing juvenile court attorney and you'd like to join our listserv, or feel free to reach out to us and call anytime if a systemic issue arises in your practice, and we can be of assistance. So my task today will be to cover some of the key child welfare bills introduced this session, and I'm going to go over 7 bills that we think may be most relevant to you on the child welfare side. And the first bill, child welfare bill on the list, is LG 673, and that was introduced by Senator Chris. LG 673 would permit counties to create a GAL division and states that if a county creates a GAL division, GAL appointments shall be made first to the GAL division, and then if a conflict exists, the county may appoint a GAL outside of the division. And then the bill also requires that the county board, rather than the court, upon hearing the application, to fix reasonable rates. And so this bill had a hearing last week, and I will say there were a number of questions from Senator Chambers about permitting the Douglas County Board to fix the rate. But I think that most or all of the testifiers that were there in person testified and supported neutrally. The next bill is LD 684. That was introduced by Senator Bowles. This one is up for hearing next Wednesday, I believe. It would exempt biological grandparents and then a step-grandparent who is married to the biological grandparent at the time of the adoption, if both are adopting the child, to be exempt from the adoption home study requirement. So under current statute, there's only an exception for a step-parent. And this would, again, add biological grandparents and step-grandparents to that list. A home study can still be required for those individuals if so determined by the court. And then a national criminal history record information check and a check of the central registry is still required. It also makes medical histories discretionary for those parties for biological grandparents and step-grandparents. And then LB 697 was introduced by Senator Howard. It directs the Department of Health and Human Services to file a state plan amendment with the federal Medicaid agency on or before May 1st of 2017 to provide for the utilization of money for payments for FFT for children under Medicaid. So I assume most of this crowd knows that FFT is functional family therapy, which is an evidence-based family therapy and juvenile diversion program for at-risk youth. This is a follow-up bill to bill last session to do the same with regard to MST for multisystemic therapy. And I believe that state plan amendment has been submitted and is still pending, but I'm not for sure on the status of that. I will say it's Appleseed's position that these are already required services under the EPSDT provision of the Federal Medicaid Act, but submitting an amended state plan would give Nebraska clear authorization from the federal CMS to use federal Medicaid funds for this important treatment. Okay, and then LB 707 was introduced by Senator Koash. This one would add a juvenile judge in Omaha. So the language of the bill is in counties having 400,000 inhabitants or more. A similar bill has been introduced in previous years, so I'm not sure the outlook this year, but I know this is very much needed in Douglas County. And then the next one is LB 744 that was introduced by Senator Watermeyer. It permits adopting and birth parents to enter into a written agreement to permit communication and contact after the placement of an adoptee between the adopting and birth parent. And this is specifically in private and agency adoptions of adoptees who are not state wards at the time of placement. So this is an interesting one. The bill states that the agreements may include provisions for future contact and communication, sharing of information, and other matters relating to communication and contact. It does specify that consent is required if the child is over age 14. And then it states that the failure of any party to comply with the communication and contact agreement is not grounds to set aside an adoption decree, revoke or relinquishment or consent to adoption, or challenge the adoption on the basis of duress or coercion, or on the basis that the agreement retains some aspect of parental rights by the birth parent. But then the bill states that the agreement may not be enforced by a civil action. And then finally, it requires the following language to appear on the agreement in bold type. And I quote, "No adoption decree shall be set aside, and no written relinquishment of parental rights or written consent to adoption shall be revoked due to the failure of the adopting parent or birth parent to follow the terms of this agreement. This agreement may not be enforced in a civil action," end quote. So my understanding is that this is you're probably all thinking, like, those agreements are unenforceable. My understanding is that this is a reaction to the May 2016 case, Monty S. versus Jason W., which upheld a district court determination that relinquishment and consent to adoption that was conditioned on a contact agreement or an open adoption was invalid. In that case, the Nebraska Supreme Court held that the legislature had previously expressly permitted open adoptions in foster care cases under 43-162, but had not expressly done so for private adoption. So, and that would be up to the legislature to do. So, but the legislature is not doing that, obviously, in this bill. But I think the intent here is to make sure that parties are clear that such contact agreements are unenforceable. In the Monty S. case, the parties had not been so advised. Okay. And then LD 746 was introduced by Senator Campbell. That implements the Federal Preventing Sex Trafficking and Strengthening Families Act and stakeholder recommendations regarding the normalcy and youth engagement provisions of the Federal Strengthening Families Act. So it implements the federal SFA's reasonable and prudent parent standard to allow caregivers, which includes foster parents and then designated individuals at group homes, essentially, as required by federal law, to use their best judgment in determining in which age and developmentally appropriate activities, so extracurricular activities, used in their care may participate. So that's federal law. This sort of puts that into our state statute and puts some, support around that. It also implements the federal SFA's requirement to provide youth ages 14 and older with a document that describes their rights that are explained to them in an age and developmentally appropriate way. Again, that's federal law, puts it in our state statute and some support around it. It implements the federal SFA requirement that transition planning begin at age 14 instead of 16 under previous federal law in our state statute, and that the plan is developed in consultation with the youth. It also implements the federal SFA requirement that HHS provide youth leaving care with certain vital documents like their birth certificate, etc. It implements the federal SFA requirement to eliminate the use of APLA, which is another planned permanent living arrangement or independent living in Nebraska for youth under age 16, and puts into place mechanisms to ensure permanent connections and support are still pursued for youth over age 16. And then LD 746 also tasks GALs with making sure that some of these things are happening for youth by reporting on them in their GAL report. And then finally, the bill also statutorily establishes the Normalcy Task Force under the Nebraska Children's Commission. It was already established in the commission, but this was just put into statute. And I am co-chair of that task force with Katie McLean-Stevenson. So if you have any questions or would be interested in participating in the task force, or there will also be several subcommittees within the task force, or if you would just like more information about it, please let me or Katie know. This one is the LD 746 is Senator Campbell's priority bill, and it had a good hearing last week. Okay, and then finally, LD 975 was introduced by Senator Coulterman. This one prohibits the state from taking adverse action against a child placing agency because the agency declines to provide, facilitate, or provide a direct referral for a child welfare service that conflicts with the agency's sincerely held religious beliefs. And then states that a child placing agency aggrieved by a violation of this may assert that violation as a claim or defense in any administrative or judicial proceeding and may obtain all appropriate relief, equitable, declaratory, and compensatory money damages. And then it states that an aggrieved agency may sue in state or federal court and then an aggrieved agency that prevails is entitled to attorney's fees. As some of you may know, there was a lawsuit by the ACLU, the Stewart case, in which Lancaster County District Court Judge Colburn found that the state's policy of not placing foster children with same-sex couples violated equal protection. And so, I think there may be interplay with that case. I believe that case has now been appealed up on the merits. I want to mention just a couple of other bills that are not on my PowerPoint slide here, because we do have a little bit of time. And this one is on the chart. It's the last one on the back page. It's LB 1034. This was introduced by Senator Campbell. It makes some changes to the Nebraska Children's Commission, which has just, as I'm sure many of you know, continued with a lot of committees and task force under it and looking at many specific issues. And this adds a few things. It adds some language that to be clear that the scope of the Children's Commission does include aspects of juvenile justice work and the juvenile justice work that's happening. It also specifically includes a few issues that the Commission will be looking at, assuming the bill passes moving forward, including analyzing some case management workforce issues and making recommendations around that, including looking at salary comparisons for caseworkers, incentives, evidence-based training, collaboration with the university on how to increase and sustain the workforce. It also would have the Commission develop a system of care plan from prevention through treatment services, and there's some language about that. And then it also has them looking at some issues around performance-based contracting for providers. I think that covers most of it. It also includes a specific that no member of the Commission may have a private financial interest, profit, or benefit from any work of the Commission. So a number of additional tasks for the Children's Commission to look at going forward, and if those are of interest, you might want to be following that bill. And then finally, wanted to just mention LB 1032, that was introduced by Senator McAllister. It's not per se a child welfare or juvenile justice bill, except it is. That's the bill for transitional health insurance program. You may think of it as Medicaid expansion, but it's different. But it's a big priority for Nebraska Appleseed, and it very much does impact many of the families that we work with. It would use Medicaid dollars to provide premium assistance and to purchase private market health insurance plan. This would close the gap for 77,000 uninsured Nebraskans. So that bill, which is, again, we call it THIP, the Transitional Health Insurance Program, is LB 1032. Okay. And there you have our contact information. So I think we can open it up to questions now. And I see that somebody is typing. And I can just go ahead and take this question. It says, can you please elaborate on LB 746 with the sex trafficking component? And I'm happy to do that. That is a good question. I think that when people hear the name of the federal law, the Preventing Sex Trafficking and Strengthening Families Act, that trafficking piece really jumps out at folks. And so this bill is really looking at kind of the second half, the Strengthening Families Act, because, and as I said, implementing the normalcy, what I've been calling, and for others call, the normalcy and the youth engagement provisions of that federal act. And on the trafficking side, there have been a number of bills in recent years by Senator McGill and others to make some best practices changes to our statute around trafficking. But this bill introduced by Senator Campbell and that work has also been in the Judiciary Committee. This bill is introduced by Senator Campbell to look at, as I said, at the normalcy and youth engagement pieces on the HHS side. In part, that's because I think there's the normalcy task force that I mentioned. There's also a task force, as you probably know, through the Attorney General's office looking at the trafficking work happening. So this bill does not really include any per se of the trafficking pieces. We think a lot of this normalcy stuff can be preventative of trafficking, but it doesn't have anything specific as to the trafficking pieces of the federal law. I will mention that this is also on our chart. It is LD 843, introduced by Senator Pansing Brooks.
and maybe Juliet can jump in if she's is more familiar with this bill. It is, I think, only impacting adults, but it does change provisions related to prostitution. And I think the way that it does that is it changes trafficking from an affirmative defense to part of the definition of prostitution has to include but not trafficked. It's a really rough explanation of it, but I did want to bring that one to your attention. And Juliet, if you have anything to add on any of that, feel free to jump in.
Yeah, that's my understanding as well, that it wouldn't apply to young people because young people, Nebraska already has a safe harbor provision that minors can't be charged with prostitution, that the case has to go the 3A route, situation injurious. But this, so Senator Pansing-Brooks' bill, which admittedly is not one I have worked closely on or know a great deal about, but I think the idea is if you make a consideration of whether that individual was trafficked part of the charge itself rather than to be raised as an affirmative defense, a person doesn't have to wait for trial to raise it as a defense. It's immediately considered in the probable cause in the bond hearing.
Okay, looks like somebody else is typing. We hope that it's not another typo on our PowerPoint. Thank you, Linda. We did notice that and tried to get it fixed. So it is 2016 for the record.
And we promise these are 2016 bills we're talking about.
Yes. It is an interesting process, I'll just say, while Cassie's typing. That, as Juliet said, that bills are introduced through the 10th day, and so for our organizations and many others, once they've all been introduced, it is kind of an interesting process and a big job to read through all the bills and try to identify what should go on this chart and what should be our organizational priority, and then really kind of sift through it and make sense of what's been introduced. So that's our excuse for not changing the date. Okay, Cassie's asking, does LD 709 require the hearing to take place within a certain time frame? Do you want to take that, Juliet?
Yeah, absolutely. So I'm pulling up the bill because I don't remember off the top of my head if the language is for a particular number of hours or if it is just a timely hearing. So that's a great question, an important question. So as I'm doing this, I'll walk you through what I'm doing so you guys can do this on your own for any bills you're interested in. The legislature webpage has, you probably already noticed, but has all of the bills in their bill language. So you can go to nebraskalegislature.gov, and then you can click on Introduced Legislation. You can cycle through to the number that you want. Click that number. It tells you everything you need to know about hearing, any fiscal note, and then you can also see the bill language. And it may well be Christine Henningsen, who also I think has some knowledge about this bill, is on the call. So Christine, if you know the answer off the top of your head and want to type it, that would be appreciated.
Yeah, I'll also say that while Juliet's taking a moment to look, that they did just update the website on the Nebraska Legislature's website. It's beautiful. So it's worth checking out. I like to look up statutes on there as well. So I think it's really clear and helpful to access information.
So Cassie, to answer your question, this language about the hearing was inserted into the juvenile code in the portion of the statute that already described a detention hearing. So it is just part of that section, which had the requirement of 24 hours excluding non-judicial days. Oh, and Christine got that too. Thanks. Anything else?
I think that both, just as a little public service announcement, both of our organizations send out updates on bills. So if you're wanting a way to track some of these going forward and kind of see what's getting traction and what's not, and when things are being heard. Voices has a As a Kid newsletter. Hopefully a lot of you are already on that, and Appleseed has a legislative update email as well. And also our Foster Care Reform Legal Resource Center. We have our email list. We send monthly updates with legislative bills and the tracking. So there's lots of ways to keep track of things.
Sarah or Juliet, this is Katie. Could you talk a little bit about the hearing process, and if folks are interested in either attending hearings or watching hearings, how they might do that?
Yeah, absolutely. So, so as I said at the outset, every bill that's dropped is entitled to a public hearing, and there are some, usual suspects around the legislature, ourselves included, who have worked on bills or, this is the job is to do policy advocacy, who are frequently there on hand to testify regarding particular pieces of legislation at the public hearing. But they're public hearings, so that means, anyone in the state who's following a bill is entitled to their time to come out and speak about it. So as I said, in a short session, everything happens fast. So we're already a couple weeks in, and that means we've already, many of the bills we spoke about today even have already had their public hearing. However, there are some we spoke about, and certainly many on the chart that haven't had their hearing yet. So they get scheduled, and essentially what you have to do is you have to watch the Nebraska Legislature webpage. They have a calendar of hearing schedules, and you can check week by week, or you can set, between certain dates and see what bills are coming up for hearing in front of what committee and on what day. Or if you're interested in a particular bill, as Sarah said, you can get on our listserv, and we, or both of our listservs, and we email out about this kind of legislation, helping keep track of when things are happening. So at the hearing, depending on which committee you're in front of, they each have different rules about how much time you get. But you can testify in person, either supportive, opposition, or neutral. Or the committee also accepts letters in lieu of testimony. So if you aren't able to be present on a particular day to testify in person, or some senators like to only have a couple in-person testifiers on their bills and they prefer letters of support, et cetera, then you can submit those either if there's someone sort of coordinating the testimony working on the bill to them, or you can submit it directly to the committee clerk and the chairman of whichever committee the bill is in front of.
Yeah, and then on the legislature's website, Katie talked about live streaming the hearings. If you go on nebraskalegislature.gov, there is an NEP live video streaming button on the right-hand side. You can't miss it. And you click on that, then you can stream the hearings, and then you can also stream floor debate. And I assume that other folks on the call are kind of nerdy and think that is fun. If you haven't done it, it's really interesting and worth doing, particularly if it's on a bill that's related to the work that you do. It's really interesting to see some of the floor debate on those issues in the hearings as well. So that's great if you can't be at a hearing. You can sort of tune in and see who's testifying and what questions the senators have and what issues are coming up. So that's all available on the legislature's website.
We still have a few more minutes. Are there questions that folks would like to ask of either Juliet or of Sarah? If you're not interested in doing so on the call, their contact information is listed here. Perhaps, go ahead.
Oh, I was just going to make sure people saw, and thank you, Christine. She put links in the chat box to the hearing dates coming up, and also to how you can stream. I think she's got here how you can stream the testimony and the floor debate.
For those that are on the call still, could you respond in the chat box if you like this sort of a format for this type of content, if this information was useful to you today? And it looks like we do have a question here from Susan Reff. If any of of these bills are passed, when do they take effect?
Susan, if the bill is enacted with an emergency clause or an E-clause, then it takes effect immediately. Off the top of my head, Sarah, I'm not sure if any of the ones we mentioned have E-clauses right now. If it doesn't have an E-clause, then I think it's 90 days after the bill is enacted, after the governor's signature. So most bills, it would probably be midsummer, since the governor would sign probably towards the end of April.
Great. And our Facebook page is facebook.com/NE Appleseed. Okay.
Well, it looks like folks have found this format to be helpful. I'd like to extend a special thank you to Juliet and to Sarah, who were putting this together while they were busy at hearings and looking at bills and getting information ready for their stakeholders. So I know that to do this in a timely way took a lot of effort given the short nature of the session. So we appreciate it very much. And if you have further questions for either Juliet or Sarah, please utilize their contact information. And thanks everyone for participating today. Bye-bye.
Have a good one.